The defense is today expected to continue to cross-examine Magistrate Vivian Cronje in the trial within a trial. This is in the Senzo Meyiwa case in the High Court in Pretoria. Of course, 5 men are on trial for gunning down the soccer star in Vosloorus, east of Johannesburg, in October 2014. Now, on Friday, the court ruled that the recording of an alleged confession of one of the accused, Bongani Ntanzi, was made without his consent. It said the alleged confession should not be admitted as evidence in court because Ntanzi's constitutional rights were violated. SABC News reporter Sipho Kekana joins us live for an update. Sipho, a good morning to you. So I imagine that we're expecting that this recording is still very much a talking point even for today.
Good morning, Naledi. So this particular confession, you'll recall that the recording itself has already been ruled that it was inadmissible because it had violated the accused, that is accused number 2, Bongani Ntanzi's constitutional rights, and because of that, it has already been ruled that it was not admissible, so it will not be admitted as part of the evidential material in these proceedings. However, that was just like the first leg of this battle on the confessions made by accused number 2. So the defense won that particular first leg, and now we moved to the written confession statement that Magistrate Vivian Cronje says she took from accused number 2 on the 24th of June, and that we are expecting is going to continue to be the talking point today. You recall that on Friday, to advocate Tulani Mgomezulu tried to poke holes in that particular written confession statement, putting it to Cronje that Ntanzi had not consented, firstly, to making that particular written statement, saying that Ntanzi had made that particular statement under duress. Mgomezulu cited issues of possible psychological manipulation, and this is with regard to the presence of the heavily armed police officers that Cronje herself told the court that were present outside of the office where Ntanzi made this particular confession when she arrived. She told the court that during the confession she was told that the police had already left, but Mgomezulu insisted that the mere presence of the heavily armed police officers on that day at that office, even though it was not inside the office where Ntanzi is understood to have made that particular confession, could have induced or put pressure on Ntanzi to make that particular statement.
Right.
And but Cronje denied this, saying that the confession was tendered freely and voluntarily. So yes, you are right there, Naledi. We are expecting this particular to continue.
Sipho, I imagine that
attention,
I imagine that, of course, some questions are going to be asked around what sort of accountability then is available for accused number 2, Bongani Ntanzi, if it really is found in this trial within a trial, and the conclusion really is that that confession was made under duress, right? I mean, what then happens to the likes of Magistrate Cronje in that matter?
So at the moment, it is a matter that is still being fought against by the defense. We are today, Advocate Charles Mnisi will start cross-examination of Cronje and try to poke more holes into that statement as the defense tries and argue for the inadmissibility of these particular confession statements, as well as the pointings out and the warning statements that we understand were made by accused number 3, 4, and 5. So we are expecting that that is going to continue, and the defense will be hoping at the end of this particular trial within a trial, perhaps like we have seen with this confession recording, they will be expecting that Judge Ratamokwatleng will again rule that these written statements, written confession statements, are inadmissible. However, the defense, Cronje has so far insisted that everything was above board with this particular written statement. Mgomezulu has argued that the statement itself was not signed by the accused, by Ntanzi. And what Cronje then told the court was that even though the signature that appeared on that document was on the last page of the pro forma confession statement, and even though there was no statement on the confession statement itself, it did not mean that Ntanzi had not tendered this confession freely and voluntarily. There are two parts to this document, Naledi. There is the first part, which is just the pro forma statement, and on that pro forma statement there is a signature of Ntanzi. On this confession statement on this document, the second part of this document, there is no signature. There are only initials on each page of the statement, and Mngomezulu was trying to push Cronje to concede that there was no signature by Ntanzi on that particular statement, and he also argued that on that particular day Ntanzi was not represented by any legal representative, and this is because Cronje had told the court that on the day she had been introduced to a gentleman by the name of Dominic Njiago, who she was told was Ntanzi's lawyer, and she says that she was able to pick up even from the conversations between Njiago and Ntanzi that indeed Njiago was a man known to Ntanzi. However, Mngomezulu last week then put it to Ntanzi, put it to Cronje rather, to say that Ntanzi had said that he did not know who that man in suit was. He was not legally represented when he made that particular confession, and those, Naledi, are the issues. We are expecting that the defense will try to stick on and try to poke more holes into those confessions.